Hello, hello, all. This is David with I'm So Offended. Just wanted to touch on something because this is, uh, I get this question a bit, and, I've provided um, one of these documents when I'm trying to explain um, jurisdiction to guys that I've talked to. So this here is child support special appearance. And of course, I do got to stay for the record. Um, this is for entertainment and educational purposes only. I am not a lawyer. I don't practice law. And do not take this as legal advice. Not responsible for how uh, you do whatever it is you do with any of the information in any of the videos on this channel. I'm so offended. Alrighty. So as far as child support, and I kind of explained in the jurisdiction video, is the fact that first of all, women don't have a legal right to it, and we know this from the case laws that exist. Um, from Blasting versus Freestone, and I believe it's Holmberg versus Holmberg, where they don't have a federal right to it, and it's the state's money. It's the state that's coming after you. The state is suing you, and the mother is nothing more than their witness, right? And so it's it's a claim that they are alleging against you for a debt that you didn't agree to, that you didn't give consent for, and so where is their authority? Where is their right? Where is their jurisdiction to say that you owe a stranger with a badge that says state money, right? Where is that? So, since this is all administratively, and as we learned that child support hearings are presided over by a person who is not a judge, so to state, quorum non judice and all this other stuff is like basically saying that they're following the rules, because child support hearings are presided over by a person who is not a judge. And if I'm like way too far than what you guys know, then about that, then that's what it is, and then you can research it and look at it from there. That's not what this video is about. This is about appearing right before their fake court, right? So, as far as appearance, because all appearances are a general appearance, and that's therein where lies the personal jurisdiction. So there is the special appearance, which, as you can see here, in from Cornell, right? So this is straight from where the laws are held, where a lot of them are put together and written from, as far as what is the standard of law. So the special appearance says there is a tool defendants can use to challenge a court's jurisdiction over them. If a court does not have personal jurisdiction, or there are other errors like the service of process, many states allow defendants to challenge the lawsuit without submitting to a court's jurisdiction, right? Normally, if the citizen were to make a general appearance, the jurisdiction issue would be waived. For federal courts and some states, a defendant does not have to make a special appearance, but they are required to challenge the given error before addressing the actual claim itself, as one would in a general appearance. Special appearance may also refer to other unique appearances by an attorney or individual, such as an attorney appearing before the assigned to the case. So, challenge the given error before addressing the actual claim. Did child support your debt? When did you agree to it? When did you consent? When did you agree to owe the state money? Where is that document? Now, I'm sure there's the the birth certificate that we can all talk about, of course, where you signed that and it says the rights and responsibilities, but there was no meeting of the minds and nobody broke down the full disclosure of the terms and the legal consequences, right? So you can challenge it if they come after you later. It's like, well, that's your special appearance, right? Your jurisdictional challenge. All right, so states do it differently, but some of the biggest states where this is in, I have a couple here that show that it's part of their procedures and it's a valid defense that you're allowed to do. So herein is because I just spoke to somebody about this, and let's go to Rule 120A. This is special appearance in Texas, right? Texas Rules Civil Procedure Rule 120A. So now, when you make your special appearance document, which should on the forefront always be the first document you file, always. So that way you let them know from the very beginning, like, you don't have jurisdiction over me. Where is your authority coming from for this stranger with a badge that says state to come after you in a lawsuit for a fabricated debt, right? So Texas Rules Civil Procedure 120A. There it is. Notwithstanding the provisions of Rules 121, 122, and 123, a special appearance may be made by any party either in person or by attorney for the purpose of objecting to the jurisdiction of the court over the person or property of the defendant on the ground that such party or property is not amendable to process issued by the courts of this state. A special appearance may be made as to an entire proceeding or as to any severable claim involved herein. Such special appearance shall be made by sworn motion filed prior to motion to transfer venue or any other plea, pleading, or motion, provided, however, that a motion to transfer venue and any other plea, pleading, or motion may be contained in the same instrument or filed subsequent thereto without waiver of such special appearance and may be amended to cure defects. And actually, we could go down to the last sentence of that paragraph. Every appearance prior to judgment not in compliance with this rule is a general appearance. All right, so this is the first thing. So in Texas, you can reference this when you're filing your special appearance. You can file your affidavit of special appearance, not a general appearance, under Texas Rules Civil Procedure 120A. And then you just copy and paste, parts of this paragraph here. Basically the first line or even the second line here, a special appearance may be made as to entire proceeding. And that's basically all you need. That's enough. According to this, that is enough. Right? It's not rocket surgery. All right. So we're going to look at what state was this here? There's another one that I have here. No, it's not. Here it is. Okay. It wasn't loading down, but now it is. All right, so this is from Orange County Family Courts. This is California, right? So we see it here. Special appearance. All right. So a special appearance is the only way to preserve objections to personal jurisdiction. For example, the party must make an appearance for the sole purpose of objecting to the court's jurisdiction. This has to be clearly stated. The record must reflect such a special appearance claim. And jurisdiction is not the only issue that can be raised by special appearance. Defective service of process can also be raised by special appearance. Now, California does this thing where they have like a lot of the forms that are already ready, and it's simple where you just kind of like check boxes and stuff like that. Um, you know, if they don't have ready forms, um, what you can obtain usually from the clerk or from the law library or whatever it may be is a general form that's kind of like a format form where you look at their format and then you create your document from that. So I've created a special appearance form, and um, you guys can borrow from this if you like. If we speak on the phone, um, you know what I mean? This would be something that I can send to you. If I gotta like type up stuff like specific to your need, then, obviously that's gonna take my time, and I can't just sit there and do that. I'm sure everybody needs help and everybody's broke. Everybody is. I'm broke. We're all broke. Everybody's broke, I'm sure, because I keep hearing it, you know. But if you really care about what it is you want to do and you want to get things done, whatever, you're going to have to spend some money, whether it be on an attorney or someone to write up your stuff, you know. But I'll let you guys use this. This is a general special appearance form that I've created, that I've used, and you can use this if you'd like. So it's basically, and this is from the format that I had used in my state. The formats vary from state to state, but you could basically, once you get the format down, then you start plugging in pretty much the same thing. So you have your name, address, phone, impropria persona, affidavit of special appearance, not a general appearance, whether you're petitioner, plaintiff, or their respondent, defendant, the names, the judge, whatever it may be, or commissioner, magistrate, whatever. You put the name. Propria persona, wrongfully accused, here and after the accused, name allegedly as whatever the title is. Make this affidavit a special appearance, not a general appearance. Now, again, if this was Texas, right, then you might put affidavit of special appearance, not a general appearance, under Texas Rules of Civil Procedure 120A, right? Just to strengthen your document, because it is a rule that that you're following there. So, of course, she'll take judicial notice. The accused will appear by special appearance under threat, duress, and coercion that's the name of the hearing, whatever the summons is. Like if it's called a something proceeding, review hearing, whatever, put the name and then you put the date and time, right? You're going to arrive and be present to demand the case be dismissed with prejudice for due process violations, fraud on the court, or you can put down for lack of subject matter jurisdiction and personal jurisdiction, for defective process of service, or all three of those. Doesn't matter. Your situation is yours. For the record, the accused does not consent to these proceedings. Accused does not consent to being the surety in these proceedings. Demand the bonds be brought forth. See who will indemnify accused. It is the accused who is damaged in this matter. Any further litigation is pointless. The fraud has been uncovered. Your verification, notary, state of, county of, name duly sworn. You fill that in, foregoing. So this is your sworn affidavit of special appearance. And then your signature, impropria persona, right, small name, allegedly, big name, petitioner, plaintiff, respondent, all rights reserved, UCC 1308. And there is your special appearance. This one single document could end it all. At least at least tells them that you're not there to play. You're not there to play. All right. And I'm not sure what your state is, but you can put in your state and then civil rules of civil procedure and put in special appearance. And then if they have your rule, then you plug your rule in and then you add more of this to strengthen your document, right? If we're talking California, if we're talking Texas, whatever it may be, there's your special appearance. You're challenging their jurisdiction. You don't consent to the hearing. You don't consent to their lawsuit. You don't consent to anything that they got going on. And as you've seen in the videos, I don't even talk to them. I don't consent to talking to them. I don't consent to anything. I'm just not interested. All right. So, appreciate the questions. Appreciate everybody liking and subscribing and peeping the videos, and like and share all that good stuff. And the email is in the about section, and that's all we got going on for today. All right, special appearance, child support. Do not consent to anything. Let them know where you stand. You make your position. You stand your ground. All right.